everybody. Happy Friday night. Welcome to the Bill of Rights Institute content webinar review for the AP Government and Politics test that's upcoming. We're happy to have you here to help you prepare for this test. Tonight, we get to focus on civil rights, which is an amazing topic, and I'm very excited to listen. I'm your BRI host, Liz Evans. I'm the Regional Programs Manager here. I did teach AP Gov for 6 years, so I will be monitoring the chat and answering any questions that I can. However, I am going to let the absolutely wonderful Paul Sargent do the teaching tonight. Paul is from Hershey, Pennsylvania, and he's taught AP Gov for 15 years. We're so happy to have him leading our review sessions. And with that, Paul, take it away.
All right. Thanks a lot, Liz. Well, yeah, it's Friday night. Friday night civil rights is what we have going on today. And tonight is, I guess it's night 6 of our review session here. I'm going to go ahead and share my screen with everybody, and we'll get this night kicked off here. Here we go. And there, yeah. So here we are. Oh, this says session 8. I'm messing numbers up all over the place. But we're doing civil rights tonight. It's the 2021 AP US Government Politics Prep webinar. So let's get things moving. Now, I like starting off with the big idea here. This is directly from the College Board. And if you were with us last night, this is going to look familiar because it's the same one that I used last night. So the College Board tells you what it is that you're really supposed to get out of it, what the big picture is of the whole unit. And so here's what we have. Through the US Constitution, but primarily through the Bill of Rights and the 14th Amendment, which we talked a good bit about last night, citizens and groups have attempted to restrict national and state governments from unduly infringing upon individual rights essential to ordered liberty and from denying equal protection under the law. Equal protection under the law is what we're going to be talking about tonight. Likewise, it has sometimes been argued that these legal protections have been used to block reforms and restrict freedoms of others in the name of social order. So we tackled a lot of this last night. Tonight, we're going to take on the rest of it. Tonight is, as I've said, civil rights. So here's an enduring understanding. This is really what, again, the College Board kind of wants you to know. The 14th Amendment's Equal Protection Clause, as well as other constitutional provisions, have often been used to support the advancement of equality. And here we have one of the iconic images from the civil rights era of Martin Luther King and others marching for equality and making being part of a social movement. So it's important, I think, that we look at the 14th Amendment itself, at least part of it, in order to understand where we're coming from here. So written into the 14th Amendment is this: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. That part, the due process of law part, is what we talked about last night with civil liberties. But tonight, we're going to continue on with nor deny to any person within its jurisdiction the equal protection of the laws. So states cannot make or enforce any law that denies a person within its jurisdiction the equal protection of the laws, not which denies a citizen, but any person within its jurisdiction. So what we're talking about here is social movements. And largely when we talk about civil rights, they all begin as social movements, some sort of push for equality. The civil rights movement is sort of the blueprint for the rest of them. This occurred in the 1950s, 1960s, and a little bit into the 1970s. But there have also been social movements for the rights of women. There have been movements for LGBTQ rights and many, many others. Now, The thing about the 14th Amendment is that the Equal Protection Clause really can support these movements. So as these movements are out there saying, people in these movements are saying, hey, we want equality, we want to be treated the same as other people in society, the 14th Amendment Equal Protection Clause supports those claims, especially, of course, when it comes to court cases. But the 14th Amendment can also motivate movements, because people who are looking to start something up can look to the 14th Amendment, see its guarantee of equal protection, and thus say, well, hey, what about me? So social movements are really important. And it's important to know that the changes which have brought more equality, I'm going to say, in the United States have been started at the ground level, at the grassroots level, by people forming together to demand equal treatment. So civil rights, of course, is as I said, the blueprint. This is the one that all of the rest of the movements have taken cues from. And really, what civil rights are themselves are their protections provided by the government to individuals against arbitrary actions of others. So it's the government actively protecting individuals against other individuals based on things like race, national origin, religion, gender, all of those. And there are certainly many more, but these are the ones we're going to highlight in tonight's discussion. And it's that Equal Protection Clause of the 14th Amendment, which I'm going to hammer home tonight because I want you to get that, that really underpins the whole idea of civil rights. Now, the civil rights for African Americans was, of course, the movement we're going to take on first. And really, I believe this is a test of Madison's theory in Federalist 10. See, in Federalist 10, if you recall, Madison put out the idea that that a large republic would be too big to allow factions to develop to the point where a majority could tyrannize a minority. But in the case of African Americans throughout American history, it's been shown that a majority, read white, can oppress a minority, read black, if they have the numbers. And so we have essentially a long history of slavery, starting right around 1619 and going up to the end of the Civil War. And after the Civil War, we see the passage of 3 Reconstruction Amendments, the 13th, 14th, and 15th Amendments. These are 3 that I really think you should know. The 13th Amendment freed the slaves. The 14th Amendment, which is what we're talking about here, did a lot, but its main purpose at the time was to guarantee citizenship for freed slaves. And then the 15th Amendment guaranteed the right to vote to Black males. And so, we have this period of Reconstruction where there really was a little bit of hope for the African American community. But by the end of Reconstruction, that had sort of gone away. And the rights of Blacks throughout America, but especially in the South, were really kind of threatened. This brought America into the era of Jim Crow. And in the era of Jim Crow, you see pictures like this: segregated facilities throughout the South, white versus colored, separate places for, in this case, water facilities of some kind, but separated in all aspects of society. And it was those Jim Crow laws that segregated the South largely. Now, there were a lot of things in place to try and keep this going. See, one of the main powers that comes in a democracy is the power to be able to vote. And with the 15th Amendment having guaranteed the vote, I guess I should put that in quotes, guaranteed the vote to Black males, and then of course the 19th Amendment adding women into that equation, the states in the South had to get creative, and they did. Many states implemented what were called white primaries. See, at the time, the Democratic Party was really dominant, I guess, throughout the South. And usually Democratic candidates would win in a race. So the only real race that mattered, if a Democrat was going to win against a Republican, then, and that outcome is pretty much already set, then the only race there really is in the Democratic primary when Democrats are running against Democrats. And many areas passed laws that created white primaries so that blacks were disenfranchised from the primary. And then when it came to the general election, they could vote, but not in a race that really would make any difference. Other areas put down poll taxes, which put a financial burden on voting. Individuals had to pay a tax in order to in order to vote, which disproportionately disadvantaged those people who were poor. And in the Jim Crow South, poor people, or I should say Black Americans, were generally poor. But there were also literacy tests that were made in order to further disenfranchise others. And those became pretty much the most effective barrier to voting. Now, was it possible that there were poor, uneducated white voters? Absolutely. But many areas put into place things called grandfather clauses, which stipulated something along the lines of, if your grandfather could vote, then you can vote too, kind of thing. Effectively sort of giving a green light to white voters who couldn't pass those different barriers. So it's definitely an unequal society. And it was unequal in terms of segregation. Now, understand, segregation in the South was something that had been upheld by the Supreme Court. In the case of Plessy versus Ferguson in 1896, the Supreme Court decided that separate but equal facilities were okay. Well, of course, when you say something like that, the question becomes, what does that mean? Separate, okay, well, what does separate mean? Does it mean that we, if we have a restaurant, do we need to have separate restaurants for blacks and whites? Or does it mean that we can have separate seating areas in a restaurant? Well, that wasn't really the part that was really widely contested. But the equal part was where things started to fall apart. And you started to see vast inequalities in the facilities, I guess, that were provided for Black Americans versus those provided to white Americans. But that separate but equal doctrine lasted for almost 60 years, really until 1954. And it's important to understand that segregation was a system which was really designed to create a hierarchical difference between blacks and whites in the South, because it really only applied in situations where there would otherwise be equality. So if, let's say, there was a workplace where the boss was white and maybe the managers were white and the workers were all Black, and there was a definite sort of hierarchical difference there, then there was no need to enforce segregated facilities laws, because the hierarchical structure was already there. But in something where there would otherwise be equality, like, let's say, in a restaurant where everyone's going to get served the same food, and it's just a matter of sort of where do people sit? Well, then there needed to be something, that was the thought at the time in the South. There needed to be laws in place to do that separation. All right. Now, women's rights also started off as a response to problems that were rising. And yes, we're going to come back to the civil rights movement. I'm not going to leave it where it was, but just bear with me and we'll move along here. There was a suffragist movement which started in the mid-19th century, where women were pushing for the equal right to vote, seeing that as a leg up in terms of getting society changed to sort of help to help meet their expectations and to fulfill their expectations as citizens of the United States. Well, it wasn't until 1920 when the 19th Amendment gave women the right to vote. So this was a long movement that women went through in order to get this. The second women's rights movement really started up in the 1960s, and you could almost pinpoint the creation of the National Organization for Women as sort of being the real beginning of the modern women's rights movement, which started in 1966 and pushed for more equality in society, pushed for equal access to things. And one of the things that really women were able to get was more opportunities through something called Title IX. I'm going to tell you a little bit more about Title IX in a few minutes, but just suffice it to say that this gave women more opportunities in terms of things like sports and education at schools that were funded at least partially by the federal government. What this did, of course, is this gave us modern American women's sports successes. Look at this. This is the World Cup champion women's national soccer team from the United States. That's a long title, but you get the idea, right? They won the World Cup. In fact, perennially, the Women's World Cup, the women's national team is ranked either first or second in the world. Contrast that with our men's national soccer team, who is always on the cusp of maybe not even qualifying for the World Cup, and has never made it to the World Cup final, much less won a World Cup. Now, the reason, or at least one of the reasons why we do so well on the international sports circuit for women's teams in things like the Olympics and in gymnastics and in soccer and things like that, is because Title IX gives equal opportunity to girls at a very young age in order to start, developing these skills. And quite honestly, most of the rest of the world doesn't have necessarily something like that. And so we have a very strong sports program. But in a show of modern inequality, the men's national soccer team gets paid more than the women's national soccer team. Think over that one for a minute. Now, one of the foundational documents that you're going to be responsible for knowing is the letter from a Birmingham jail, written by Martin Luther King, and in which he defends the idea of civil disobedience as a way of challenging segregation laws in the South. Now, hopefully you've read this, because his writing is very well thought out, very eloquent, and really lays out a great case for using a civil disobedience movement that was combined with nonviolence in order to create change. And the idea is that civil disobedience actively disobeys laws which are deemed unjust, in which the participants disobey the laws nonviolently, but also accept the consequences for breaking the laws, like, for example, being in jail. And they accept those willingly in order to protest the justness, I guess, of the law in question, maybe segregation laws. So certainly you want to be sure that you know this. Now, some social movements, just to touch on this one more time, the National Organization for Women is an example of women coming together as a social movement to try and create change. We also see social movements like the pro-life movement, which are grassroots movement there trying to change policy on abortions in the United States. So certainly we have lots of these movements going on. Now, what happens to the movements? Well, understand this: public policy promoting civil rights is influenced by citizen-state interactions and constitutional interpretations over time. So let's take a look at those citizen-state interactions and constitutional interpretations. All right. So really, the question is, how do governments respond to social movements? So if you have a growing civil rights movement, like we see here in this picture, how do governments respond to this? Well, generally speaking, government's responses have included court rulings. The courts have come out and ruled, upholding the 14th Amendment and its Equal Protection Clause. Legislation has been really important. Congress has come forth to make laws that respond to social movements, and executive actions have happened. So presidents have taken action in response to social movements. So let's look at a few examples, because it's important in a government course to know how government responds to these things, because unfortunately, a social movement in itself doesn't usually get something done. The social movement can bring up an issue and can draw lots of attention to the issue, but in order to create permanent change, you almost need government action. And that's what brings us to the 14th Amendment's Equal Protection Clause, because it requires government to do this. All right. So during the civil rights movement, you have leaders of the civil rights movement out there, including preachers, students, Northern activists, all of which are trying to push for an end to segregation. And you have mass demonstrations that go on. One of the real challenges that the mass demonstrations had to overcome was something called the free rider problem. And the free rider problem, very simply, is this. If you have a large group of people who want to make a message known, it's very likely that lots of people within that possible group would say, you know what, this march is happening, and probably, actually, I'm going to get arrested if I go and do this march. We're not going to see any change if we don't march, but no one's going to miss it if I'm not there. And if you have too many people who become free riders, then your movement loses steam because it doesn't have the people to make the movement big enough. So really, they had to overcome this potential free rider problem. Well, they were able to do it through a great deal of organization and a constant, clear message coming from all parts of Black society about the need to make change and the need to make their voices heard. And so what you have is you have marches and boycotts across the South that brought national attention to the movement. And they used nonviolence and civil disobedience to get the movement on camera so that the news people would film this movement going on and then pass that film on to the news so that it could be seen around the country. And really what the sort of genius of this was, and this is kind of the goal of civil disobedience, is civil disobedience causes violent responses by those who are in power. So during the civil rights movement, violent responses by white Southerners were what were caught on camera. And so people around the country who might not, living in the North, living in the West, might not have really ever experienced segregation, or might not have ever really, maybe not even thought about it all that much. They're now watching the news and they're seeing Black citizens who are peacefully trying to demonstrate or march or, do a sit-in or whatever for equality being attacked and being brutalized by white Southerners. Now, as they saw that, public opinion began to turn and began to favor the protesters. This is where government stepped in. In 1964, Congress passed the Civil Rights Act of 1964, and President Lyndon Johnson signed it. You can see him here. It had to overcome a filibuster in the Senate in order to be successful. And we talked about the Senate filibuster a few days ago, the ability for senators to talk for an extended period of time in order to slow down legislation. But Lyndon Johnson, who had been in the Senate himself, really was able to create a coalition of senators that were large enough to push the bill through over the opposition of Southern Democrats who didn't want to see this, the end of segregation. And what the Civil Rights Act of 1964 did is it gave the federal government the power to end segregation. It gave them the power to step in and end segregation in schools and in public facilities. So this was the federal government stepping up and saying, we're on the side of these protesters. We're on the side of these civil rights leaders. We're on the side of these people who want their equal share of America. But that wouldn't be enough. So Congress quickly followed up with the 24th Amendment. The 24th Amendment prohibited poll taxes. And what we have here is we have a poll tax receipt from the state of Texas. I'll show you a closer picture of it because it's one of those sort of relics of the past that is interesting to look at. But the 24th Amendment eliminated poll taxes, and it gave the power to the federal government to enforce the law in states that wanted to keep having poll taxes. Now that's important because passing an amendment and then sort of leaving it up to the states to enforce it wouldn't have done very much good. Let's see what happened with the 14th and 15th Amendments, right? They weren't enforced very well throughout the South, but this empowered the federal government to do it. And thus it removed one more barrier to Black voting rights. Now, why are voting rights important? Well, voting rights are important because if a group of people has the power to vote, they have the power to help determine who gets into office. And that power will get politicians to cater to those people's needs, to try and garner their votes by making promises to them. And that's sort of the power of the vote. Now, if you don't have the vote and you're disenfranchised, then why should politicians ever try and do something to help this group of people out? You know, that's what democracy is. So you can see here a poll tax receipt from 1961, stamped 1959. I guess he paid it early. But you can see, I mean, it has the person's name, how old they are, what they do, how long they've resided in Texas and where they live, whether they're white or colored, whether they're native born or they're naturalized, where they were born, and they paid, it says it here, the sum of $1.50 in payment of poll tax for the year 1959. So that's a poll tax receipt for you. Now, that still wasn't enough. So Congress in 1965 passed the Voting Rights Act. And the Voting Rights Act made electoral tests in southern states illegal. It really targeted southern states that had low Black voter turnout, because that was sort of evidence of a barrier being put up to effective Black voting. And it made it so that the federal government could go into those states and could directly register voters to vote in that state. Now, this was unprecedented because since the Constitution, or since the forming of the Constitution, states had been in charge of elections. I mean, they really still are. And here's the federal government saying, okay, there's enough problems down there that we're going to empower the federal authorities to go in and register people, because we honestly don't think we can trust some of these states to equally register people. It also had a pre-clearance clause in it. And the pre-clearance clause said that those states which had a history of discriminatory laws in terms of voting would have to have their voting laws approved by Congress. But then, before they could make any change to their voting laws, those laws had to be pre-cleared by Congress. In other words, they had to send the proposed law to Congress, and Congress had to look it over and say, like, okay, yeah, this is good, before they could make any change as a state. Now, in 2013, that part of the law was ended. And the Supreme Court decided in 2013 that there had not been any change or any evidence of ongoing attempts to disenfranchise voters in those states. And so there's no longer a need for pre-clearance. Well, now, of course, in 2020, we have controversies arising in places like Georgia of states that are starting to pass some laws which have to do with voting, which have been criticized by Democrats as being restrictive and being racially motivated. So we'll see what comes with that. You can see none of this stuff is really like set in stone. Latinx rights have also been helped by governments along the way. In 1970, for example, Congress looked at the Voting Rights Act, which didn't have anything to do with the Latinx community, and decided to add to it a mandate that Spanish language ballots be available, especially in places which had significant Spanish speaking populations, in order to provide an equal access to the ballot. But in response to this, some states have gone through and adopted English-only laws for state businesses, but really including schools. Some states have passed laws saying that schools can only be taught in English, sort of a backlash to expansion of rights. And more recently, under Barack Obama, the Deferred Action for Childhood Arrival, or DACA program, was set up to protect 4 million undocumented immigrants from deportation. These are individuals who came to the United States illegally as children and have lived in the United States for a good while. And under Obama, and now again under Biden, are not facing possible deportation. And Title IX has been a response by the government to some of the concerns of women. It was passed in 1972 as part of the Higher Education Act. And what it did is it tied federal funding for these schools to non-discrimination against women. So schools that were found to discriminate against women in sports and in education, things like that, risked giving up their federal funding. Now, this included the size of sports programs, so that women's sports had to be equal in number and equally funded, as need be, obviously, to men's programs. And what this did is this vastly increased women's access to athletic opportunities. And so, government responses to things. All right, and in terms of LGBTQ rights, governments have responded to these rights as well. For a long time in the military, there was a dishonorable discharge that was given to people who were gay and in the military. But starting in the 1990s, the military adopted a "don't ask, don't tell" policy, which basically said that if someone in the military was gay, the military superiors could never ask if someone was gay, but the person who's gay could not, would never tell. And if they did tell, then they would risk being kicked out of the military. That ended in 2010. So as of 2010, gay Americans are fully welcomed into the armed forces, even openly. But you also have many states that have extended hate crime protection to the gay community, making it so that crimes which are motivated by hate against a particular group, usually gender or race or something like that, religion, have included sexual orientation in there. And prior to 2013, Congress had in effect the Defense of Marriage Act, which allowed states to prohibit gay marriage. But in 2013, that was overturned. And, speaking of overturning, we're going to move to the Supreme Court here, because it's the Supreme Court's interpretation of the U.S. Constitution that is influenced by the composition of the court. So depending on who's sitting in those seats, their ideology is going to influence how the court interprets words in the U.S. Constitution. Citizen-state interactions also do that. And so the Supreme Court at times has restricted minority rights, and at other times protected minority rights. It's a complicated history that we kind of have to deal with. So in the Supreme Court, you have sometimes some different things. Like I said, sometimes it's restricted and sometimes it's protected minority rights. Obviously, a restriction happened with segregation being allowed under a separate but equal doctrine set up by the Supreme Court. But that was brought to an end in the court case Brown versus Board of Education, which we'll talk about in just a minute. The Supreme Court has also prohibited the creation of explicitly majority minority districts when it comes to redistricting. So the Supreme Court has kind of been jumping all over the place. But the one we like to talk about is Brown versus Board of Education, coming out in 1954. Because it was that court case that effectively overturned the Plessy versus Ferguson decision, which had created a segregated South. And the decision was made by the court that separate educational facilities are inherently unequal. In other words, it's not possible to have separate schools and have them be equal. And it's not even a matter of the amount of funding, the quality of teachers, the quality of the textbooks, the commute to the school, all of that. No, we're not even worried. Simply having a separate facility creates inequality because it says to the group which is being treated as unequal, you are unequal, is what it says. And so that inherently doesn't work. And so the Supreme Court charged the lower courts with overseeing desegregation of schools with what they called all deliberate speed. And that all deliberate speed wasn't all that speedy, because unfortunately, by 1962, if we look 8 years after Brown versus Board of Education, less than 0.5% of Black students in the South were in desegregated schools. This desegregation took a long time. Right? And this speaks to the role of the Supreme Court. One of the reasons that the founding fathers said that it was okay to have the Supreme Court be an unelected branch of government with lifetime terms, if you recall that from when we talked about the Constitution, was because they did not have the power to enforce their decisions and they didn't have the power to fund their decisions. Those were held by other branches of government. Well, the Brown versus Board of Education decision was not enforced and not funded very well, if that's what we have. Now, Obergefell versus Hodges is another example of the Supreme Court stepping in when it comes to civil rights disputes. And this is a result of those states that followed along with the Defense of Marriage Act that I talked about a few minutes ago. Now, some states prior to 2015 had decided to kind of like create a middle ground for gay couples. They weren't going to allow gay couples to get married, and they weren't going to recognize gay marriages performed in another state. But they decided to do this thing called civil unions. And the idea of a civil union is it provides all the legal benefits to being married, including inheritance benefits and power of attorney benefits and things like those. But it wasn't called marriage. It was this special little thing. That didn't end up being enough. So the Supreme Court in 2015 heard a case that challenged the Defense of Marriage Act and found that the 14th Amendment is in its equal protection clause required states to license same-sex marriages. That equal protection means that gay couples should have the same protection as heterosexual couples. And they said states also have to recognize same-sex marriages that were performed in another state, sort of taking that part of it away. So it opened the door up. Now, they also went ahead and included the idea of marriage under the due process clause as well. But for our purposes today, we're going to throw it in with equal protection because it really is, in my eyes at least, very much a civil rights issue. Now, segregation also had to be tackled. And there are different types of segregation out there that you really need to know about. First is called de jure segregation. Now, this is a Latin term, de jure. It means by law, okay? So these are state laws that mandate segregation. And this is what we always learn about. This is what we always think about, the Jim Crow South with laws in place that separated people by race. But there was a whole different kind of segregation that existed elsewhere in the country called de facto segregation. And de facto segregation, Latin for in fact, like in reality, exists outside of the law. So in, let's say, the North, there was no legal segregation, but people of different races largely lived in different neighborhoods, and those different neighborhoods largely fed into different school systems. So you effectively had a segregated school system in the North that was as effective as it was in the South at segregating individuals. And so for a time, governments tried to use busing to forcibly integrate schools. What they would do is they would take students, if you have, let's say, a school A and school B, and school A is white and school B is Black, majority at least. You take about half the kids from school A and half the kids from school B, you place them on buses every day, and you have them go to the other school, thus integrating the schools. That was the idea. Hey, we can just make this happen, right? What it led to, though, was a reaction by middle class and upper class white families that began a process that's become known as white flight. where white families who had the means to do so moved out of school districts that were participating in forced busing and into white school districts that were not forcing busing, and thus moving away from the problem, which ironically resulted in more segregation than existed before busing happened. So it was kind of one of those systems that didn't quite work out exactly how people wanted. Now, a lot of the modern discussion of equality centers around affirmative action. And affirmative action is really a set of policies designed to help historically disadvantaged groups. So the way I like to think of it is this, okay? In an ideal world, you have a level playing field where everyone, regardless of age, race, gender, religion, sexual orientation, et cetera, have equal opportunities and an equal chance, really, of reaching the same level of success in society. Okay, that would be an ideal society. At least I think so. But in American society, the reality is it's not like that. Okay, there are traditionally advantaged groups and there are traditionally disadvantaged groups, and those disadvantaged groups have a harder, like they have an extra leap that they have to take, I guess, in order to climb the social ladder. And so affirmative action programs kind of said or say, okay, well, let's take these people who have been disadvantaged and let's give them a little bump. All right, let's make them, just even them up somehow so that then everybody starts off from the same playing field. Sounds like a good idea, right? Well, the easiest way to do this early on was through quotas. And the idea of a quota is they might look and say, like, okay, well, if they're admitting a freshman class to a university, they could look and say, well, the Black population in America is around 12%. So we're gonna set a quota that 12% of our freshman class has to be Black in order to get in admissions, right? Well, this became its own court case because in the Regents of California, the University of California versus Bakke decision, a white male was not admitted to a university program at the University of California. And he challenged it, saying that the quota system had disadvantaged him as a white male. Now, if you're listening to this, you may be sitting there going like, wait a minute, you can't discriminate against white males. Well, guess what? The Supreme Court said you can. And in fact, equal protection for one means equal protection for all. And a quota system can, just not necessarily does, but certainly can discriminate against individuals who are trying to get into that university. And so what really happened was they found that quotas violated the equal protection of white applicants, and so banned the quota system. Now, since then, universities have tried many different systems to try and keep affirmative action alive and well. But the problem is that all of the things that universities have come up with have created their own problems. So affirmative action today, universities can consider race in the admissions process, but they can only use it as one of many factors. So think getting admitted to college, an individual could be judged on where they went to school, high school, and their GPA and their SAT scores and the clubs that they're involved in and their AP scores and all these other things, including extracurricular activities. And and we can also throw in race as one of those factors. That's okay. But it's important to know that colleges cannot make the decision based on race. So race cannot be the deciding factor in a decision to admit a student, because once race becomes a reason, if it becomes, hey, we admitted this person because this person is Black, for example, then that automatically becomes discrimination under the 14th Amendment. So what really happens is sort of this weird thing where most Americans really favor affirmative action in principle. You know, they like the idea of evening the playing field, of making up for past wrongs. But the majority of Americans disapproves of every single method that's ever been tried to implement it, because every time something is implemented, it ends up being discriminatory. And that's one of the real challenges we have going forward. So that is really about all for civil rights. So I hope you understood all of this. Civil rights can be can be confusing. It can be frustrating, and making really lasting social change can take a very, very long time. And if we look at recent events like the protests that happened last summer and the ongoing protests even today, we can see that a number of people in America don't believe that civil rights equality has been achieved. And if that's the case, it's going to take social movements to push this idea forward. It's going to take the actions of government in order to fully or to further, I guess, equalize society. And it's going to take the Supreme Court to uphold those moves and continue to support equal protection under the law. And if that happens, who knows? We might have an equal society someday, but I don't think we have it today. But that's a discussion for another time. On Monday night, we're going to be back. No, we're not going over the weekend. I am impressed for those of you who are here on a Friday night, but we're going to take the weekend off and we're going to come back to you fresh on Monday night. Next week, we have 3 sessions left. Monday night, we're going to kick it off with political ideologies and beliefs. And so we'll talk about polling, and we'll talk about what people believe, and Democrats and Republicans and all of that, and get that hit on Monday. So I guess that is about all I have for you tonight. So Liz, I'm going to kick it back to you.
Thank you so much, Paul, and thank you guys for hanging out with us on a Friday night. There are links below that there's tons of review stuff that the Bill of Rights Institute has, and like Paul said, we have 3 next week. But if you missed any of the other ones, they're all available on the YouTube page to play whenever you'd like them. But thank you guys so much for attending, and we will see you on Monday. Have a great weekend.